You will recall that the motion was moved here on the 1st of this month by the Honorable Niwagaba Wilfred MP. And the bit of background that I should give you, honorable members, that you understand where my guidance is coming from. You'll recall that on the 1st of August 2019, I deferred my ruling on a procedural issue raised by the Land Deputy Attorney General on the motion seeking leave to introduce a private member's bill entitled the Constitutional Amendment Bill 2019, moved by the Honorable Wilfred Niwagaba, MP Ndora East, Kabale District. Honorable Niwagaba first gave notice of this motion on the 26th of January this year, and the Speaker deferred the presentation of this motion until the end of April. And the purpose of deferring this was to give the Attorney General's office and the Attorney General himself the opportunity to present the government bills on both constitutional amendment and electoral reforms. At the beginning of May 2019, the Honorable Niwagaba again raised this matter. He said April, which was a date given, has expired, and there has been no presentation from the Office of the Attorney General on either electoral reforms or constitutional amendment. Could he be allowed, and he presents his motion. In the meantime, another notice of a motion for leave to present a private member's bill on constitutional amendment was also served on the Speaker by the Honorable Paul Muiro. It was requested by the Office of the Speaker to consolidate his motion with that of Honorable Niwagaba to avoid the multiplicity of motions on the same subject matter. There was a protracted delay from the Office of the Attorney General, and on the 26th of July 2019, the Honorable Niwagaba again submitted a fresh notice to the Speaker on his stalled motion. Eventually, on the 1st of August 2019, after 6 months, the Honorable Niwagaba moved the consolidated motion under the provisions of Article 79 and 94 of the Constitution of the Republic of Uganda and the rules 120 and 121 of our rules of procedure. And his view was to amend the Constitution of the Republic of Uganda, and the draft bill was also attached. The Honorable Niwagaba main issues that he wanted to deal with in his proposed amendments are as follows. One is to deal with issues of the Electoral Commission, some changes that he proposes. And two, the time within which fresh elections may be held following a by-election. And three, donations during electoral period. Four, involvement of public officers in the political campaigns. And finally, five, the adjudication process, especially election petitions involving members of parliament at High Court level and Court of Appeal level. During the debate, the Land Deputy Attorney General raised objections on some of these issues. One, whether the motion does not actually require a certificate of financial implication. And two, whether the certificate of financial implication is determinant of compliance with Article 93. Because if a certificate of financial implication has not been issued, his argument was that he cannot proceed because Article 93 would bar him from proceeding with. Whether the requirements of Article 93 of the Constitution apply to draft bills accompanying motion for leave. And lastly, whether proceeding upon the motion by the Honorable Niwagaba is contrary to a resolution passed and adopted by the House in 2015 to refer all amendments to the Constitutional Review Commission. And honorable members, as you will recall, given the nature of the way we are proceeding, the Honorable Segona requested that they should give some response to what the Attorney General had raised, so that when I'm making my ruling, I could combine all those issues. Honorable members, having reviewed the issues raised by the Deputy Attorney General and the reply to them made by the Honorable Medad Segona, I now guide and rule as follows. I am alive to the provisions of Article 79 of the Functions of Parliament, Article 94, 4B, and Rule 120 of the Rules of Procedure of Parliament on the right of a private member to move a private member's bill, Article 93 on the limitations imposed on financial matters, Section 76 of the Public Finance Management Act 2015, and Rule 117 on the rules of procedure of Parliament on the need for certificate of financial implications, and finally Rule 123 on the settlement on issues of financial matters. Honorable members, you are aware that Article 94(4)(b) and Rule 120 of the Rules of Procedure of Parliament guarantee a member's right to move a private member's bill. Rule 121 further prescribes the procedure for introducing a private member's bill, which is first by way of a motion to which the proposed draft bill is attached, and that is the motion that is before us. The right of a member to move a private member's bill is not absolute and is limited by Article 93 of the Constitution. Article 93 of the Constitution prohibits Parliament from proceeding on a bill or a motion unless such a bill or a motion is introduced on behalf of government where it makes provision for any of the following. A, the imposition of a charge on the Consolidated Fund or other public fund of Uganda, or the alteration of any such charge, otherwise done by reduction. Only a reduction is permitted in these circumstances. B, the payment, issue, or withdrawal from the Consolidated Fund or other public fund of Uganda of any monies not charged on that fund or any increase in the amount of that payment issued or withdrawal. And C, the composition or remission of any debt due to the government of Uganda. Or D, the payment, issue, or warrant or withdrawal, from the Consolidated Fund or other public fund of Uganda of any monies not charged on the fund and any increase in the amount of that payment issue or withdrawal. E, the composition or remission of any debt due to the government of Uganda. And finally, upon a motion, including an amendment to motion, the effect of which would be to make provision of any of the purposes prohibited. Whereas Article 93 of the Constitution bars Parliament from proceeding on a bill or a motion that makes provision for those matters enumerated above, the Constitution does not guide on who is supposed to advise Parliament on whether a bill or a motion makes provision for matters that are barred by Article 93. I am aware that Parliament enacted the Public Finance Management Act 2015, wherein Parliament, in Section 76, imposed an obligation on every person introducing a bill in Parliament to ensure that the bill is accompanied by a certificate of financial implications. The certificate of financial implications envisaged under Section 76 of the Public Finance Management Act 2015 indicates the revenue and expenditure estimates of the intended law for a period of more than 2 financial years after commencement. It also indicates the impact of the new law on the economy. In other words, a certificate of financial implications envisaged in Section 76 does not signify that a bill complies with Article 93 of the Constitution or otherwise. Honorable members, you may recall that Section 76 was carried over from the Budget Act of 2001, which was actually a result of an amendment moved on the floor to challenge government to ensure that bills passed and assented to are implemented by the government. The background is that we used to pass bills, and when these bills are passed, there is no money to implement them. So they remain in the shelves, and they say commencement date, maybe in 2, 3, 4, 5 years, and yet Parliament has spent time passing this particular legislation, which does not have money for its implementation. So Parliament, in its wisdom, said no. For every bill now that you bring, not just for private members, but even for the government, show us its financial implications by a certificate issued by the Ministry of Finance to tell us that this bill is going to be implemented. Otherwise, don't waste our time, because we don't act in vain. So that is why that section applies to both public bills as proposed by the executive arm of government as well as private members' bills. Honorable members, you also recall that in Article 94(4), provisions are made for how Parliament should proceed with its rules of procedure. And the rules of procedure enacted are housed under our Article 94. And it makes specific provision on the right of private members to present private members' bills. So these rights are guaranteed by the Constitution. Therefore, I am of the considered view that Section 76 of the Public Finance Management Act does not and was not enacted to specifically guide on the requirements under Article 93 of the Constitution. So by issuing a certificate of financial implication, it does not now mean that you have complied with Article 93 of the Constitution.